we're going to start the meeting. Just as the logistics, just Reggie muted everybody. We're going to have an introduction by Kathy Bradford, our president, and then we're going to get right into the program. So let's first start with Kathy so she can welcome us.
Hi, I'm Kathy Bradford, this year's PV Dems Board President, and I'm going to welcome you to today's wonderful program. Our fabulous team of Biden and Harris must win. They're ahead in the polls by the same amount Hillary was at the same time in the last election, and we know how that turned out. We can't take anything for granted this year. As you know, Field Team 6 helped to flip the Orange County House seats during the midterms by registering new Democrats and running multiple phone banks. Thank you to all of you who were part of this enterprise. Field Team 6 is now using its skills to flip the presidency. Field Team 6 is registering Democrats in all 12 battleground states. Come and text and phone bank to help get this done. As always, training's included. The link to Field Team 6 is on our webpage under links. If you're more interested in local races, I recommend you look at the mobilize.us.kdem site for lots of opportunities to help. In particular, the PV Democrats are sponsoring a phone bank for Harley Ruda on the fourth Sunday of each month from now until election. Please join us by registering on the web link I'll put on the chat shortly. And I'd like to remind everybody that the PV Democrats' new year started in July and membership dues are due now. $25 for singles, $40 for families, and $10 for students. And now to introduce today's program is our second VP, Ann Nye.
Okay, thank you, Kathy. Just as one other tidbit that came up during our talk at when we were all talking at 2 o'clock, people were asking where to get Biden-Harris signs, and Reggie told us for right now the best place is to go to the Joe Biden website, so joebiden.com. And if we have any other ideas about that, we'll put it out on our website or an email. But for right now, that's where the placards are. Okay, so I'm going to introduce our speaker. Our program is Supreme Court 2019 through 20 review with Judge Tom Long. Once again, we are delighted and grateful to have Superior Court Judge Tom Long, a former RPV mayor and PD Democrats member, walk us through the video of UCI, that's the University of California Irvine, Law's 2019 through 20 Supreme Court panel discussion of the decisions and provide insight as to how these rulings will affect us. Tom is a graduate of Stanford Law School and has been a Superior Court judge since 2015 and will be up for re-election in 2025. So here's Tom.
Good afternoon, everyone. And as indicated, I am a judge on the Superior Court. I think the materials that were circulated pointed out that we are up for election periodically, but I am up for election in 2024, not 2025. We'll come back to that. That's okay. We'll come back to that when we get closer to 2024. We're going to go through a presentation today that's going to include contributions from a number of distinguished law professors, including Erwin Chemerinsky, the founding dean of the University of California Irvine School of Law, and now a professor at the University of California, Berkeley. He was the one who originated this annual review of the Supreme Court. And he's known, among other things, for his books, which I can recommend, one of which in particular, I think the first of which was called The Conservative Assault on the Constitution. He is one of the leading constitutional law scholars in the United States. Also, University of California Irvine Professor of Law Rachel Moran, Cardozo School of Law Professor Kate Shaw, and Florida State Law School Professor Michael Morley are also all going to provide contributions that will cover, each of them will cover at least one, if not two, specific cases. The Supreme Court term this year, the entire term, only had, I believe it was less than 60 cases. It's the smallest number of cases decided by published opinion since, I believe, the time of the Civil War. And as a result, you're going to hear a discussion about a significant portion of those cases, roughly a dozen cases. So with that, let me ask that we will play the first. We're going to play a series of video clips that are the highlights of the discussion. The seminar went on, I believe, for a total of close to 2 hours, and we've edited it down. And we're going to play them. And as and when you come up with questions, please go ahead and type your questions into chat. And that way we can read back your questions and try to answer them when we get to the question and answer period. With that, I'll turn it over to Anne to start the presentation that we have edited.
Okay, so I'm going to share my screen.
Thank you so much. It's a huge pleasure to be able to participate. It is hard to believe that it's been 10 years. My enormous thanks and congratulations to Rick for creating this program and for putting it together each year and for including me. In so many ways, this was a term unlike any other. The court decided only 53 cases with signed opinions after briefing oral argument. That's the fewest number since 1862, early in the Civil War. The Supreme Court canceled oral arguments in March and April. The last time the court did that was in October 1919 because of the Spanish flu. The court held telephonic oral arguments in 10 cases in May. Obviously, never before had the court had telephonic oral arguments. The court did live audio broadcasts of those arguments in May. Never before had been live broadcasts from the Supreme Court's arguments. But maybe most of all, what distinguishes this term is something that Rick alluded to. It really was truly the John Roberts Court. Chief Justice Roberts was in the majority in 97% of all of the decisions. He dissented only twice. As you know, when the chief is in the majority, he assigns who writes the majority opinion. And he wrote the majority opinion, some of the most important cases of the term. Largely because of John Roberts, there were surprising results in many of the cases we'll talk about. There were many instances where, contrary to predictions, the liberal position prevailed, such as we'll talk about, the decision to stop the rescission of DACA, the striking down the Louisiana abortion statute, enforcing subpoenas against the president, finding that Title VII prohibits discrimination on the basis of sexual orientation and gender identity. But there was one area where the conservative position consistently prevailed, and that was with regard to religion. And I think what we saw this term is a precursor of what's going to come. I think the conservative majority on the court is going to minimize the Establishment Clause and greatly expand the protection of free exercise of religion. And in my time this morning, I want to talk about the two cases about free exercise of religion under the Constitution. The first is Espinoza versus Montana Department of Revenue. Montana adopted a law that gave a tax credit to parents who sent their children to private school, whether it was secular or religious. It was a $150 tax credit. The Montana Supreme Court found that this law violated the Montana state constitution. The Montana Constitution, like most in the country, prohibits direct or indirect state aid to religion. Now, one would think that this would then be the end of the litigation. A state Supreme Court found a state law to violate the state constitution. No longer could it be said that Montana was favoring secular private schools over religious ones. Montana wasn't giving any aid at all. But the Supreme Court, in a 5-4 decision, reversed the Montana Supreme Court. Chief Justice Roberts wrote the majority opinion. Justice Thomas and Gorsuch, concurring opinion. Justice Alito wrote a separate concurring opinion. And then there were dissenting opinions by Justice Ginsburg, Breyer, and Sotomayor, and Justice Kagan joined them. Chief Justice Roberts said that whenever the government denies funds to religious institutions that it provides to private secular institutions, the government must meet strict scrutiny. This goes back to a decision from 3 years ago in Trinity Lutheran of Columbia, Missouri versus Comer. That case involved Missouri giving aid to schools for resurfacing playgrounds. The state would give that aid to public or secular private schools, but not to religious schools. The Supreme Court declared that unconstitutional, again an opinion by Chief Justice Roberts. He said there too that when the government provides aid to secular private institutions, it must meet strict scrutiny if it denies it to religious institutions. But then in footnote 3 in Trinity Lutheran, Chief Justice Roberts said, this is just a case about playgrounds, not about anything else. We now know that it was about a lot more than playgrounds. Here, Chief Justice Roberts said, Montana denied benefits solely because they would be going to religious institutions. That has to meet strict scrutiny, and the court found that strict scrutiny was not met. Justice Thomas, in a concurring opinion joined by Justice Gorsuch, said, the Establishment Clause doesn't apply to state and local governments at all. It was just originally meant to keep the federal government from creating a national church. Justice Thomas has said this before, but never before did another justice join him in this regard. It's a radical position that would mean that there's no limit on the ability of a state or local government to create an official religion or coerce participation. Justice Alito in his concurrence said, the Montana constitutional provision was one of many so-called Blaine amendments, and these were motivated in the 19th century by an anti-Catholic sentiment. That should make it unconstitutional. As I said, Justices Ginsburg, Breyer, and Sotomayor wrote dissenting opinions. They all stressed, at least to some extent, that there was no Montana law after it was struck down. There was no discrimination against religion. I think the bottom line of this is that whenever the government provides benefits to a secular private institution, it will have to provide those benefits to a religious institution unless the government meets strict scrutiny. Very little will meet strict scrutiny. I think the government needs to show that the benefits would violate the Establishment Clause. And for this court, I think little will violate the Establishment Clause. The other case was Our Lady of Guadalupe School versus Morrissey Baru. The case involves two elementary school teachers at Catholic schools. Both lost their jobs. One was a woman who had breast cancer who lost her job because of her disability. The other was a teacher who suffered age discrimination, being replaced by a younger teacher. They sued for employment discrimination. The Supreme Court ruled 7-2 that parochial schools cannot be sued for employment discrimination for the choices they make as to who will be their teachers. Here, Justice Alito wrote for the majority. Justice Sotomayor wrote the dissent, joined by Justice Ginsburg. This goes back to a Supreme Court case from 2012, Hosanna Tabor Lutheran School versus EOC, where the court said a religious school could not be held liable for the choices it makes as to who will be its ministers. But that case involved a fifth grade teacher who had been commissioned as a minister in the faith. The Supreme Court in Guadalupe School extends that beyond just ministers to say that religious schools can't be held liable at all for the choices they make as to who will be their teachers. As Justice Sotomayor said in her dissent, this means that a religious school can discriminate with impunity based on race, sex, religion, sexual orientation, age, disability, even if the teacher has no role in teaching religion. I conclude with a point that Justice Sotomayor made in tying these two cases together. In the Montana case, the Supreme Court emphasized that religious institutions have to be treated the same as secular institutions. But in Guadalupe School, the Supreme Court said that religious institutions need to be treated better and differently, exempt from anti-discrimination laws. As I said at the beginning, I think this is a harbor of what's to come, a court greatly expanding free exercise protections and narrowing the Establishment Clause.
I don't see that we have any questions yet on this discussion, but I think this is the most discouraging area of the last term of the Supreme Court, is that this whole concept of religious freedom is really a Trojan horse. I mean, what's happened is now Montana originally made a decision to try to give aid to private schools, and the Montana Supreme Court said, you simply can't do that, because if you do that and you provide aid to religious private schools, you're violating Montana's Establishment Clause. And what the Supreme Court is now saying is, no, you've essentially opened a Pandora's box. Once you provide any aid to any sort of institution like schools, you must provide the same equal aid to the religious school. So in terms of benefits, religious institutions have to be treated equally in terms of benefits, even when there's a threat to the state's establishment clause under its constitution. Yet at the same time, as Professor Chemerinsky points out, the burdens on a religious institution are extremely limited. The religious institutions are now, under the Our Lady of Guadalupe case, free to discriminate on any grounds they want, presumably including race, as well as other grounds. And that suggests that further expansion of the very broad conception of this court of religious freedom will simply overwhelm the Establishment Clause, and corporations will be able to claim that their actions are a reflection of religious values, such that they too will be able to run around, do an end run around the anti-discrimination laws. This is an extremely dangerous area that the Supreme Court this Supreme Court is treading into, and could be a real impairment for anti-discrimination laws. We edited out, and I'm going to discuss briefly the 5-4 decision that preserved the Louisiana, that preserved the precedent, striking down Texas abortion law by also striking down Louisiana's abortion law, which was virtually identical. And this has been reported everywhere as a 5-4 decision. Justice Roberts switched sides. He voted with the liberals, and it's reported as though it's some great victory for abortion rights. Were that were true, it's not. There is no opinion of the court. 5 justices did not sign on to the same opinion. Therefore, the plurality opinion in June Medical Services is just that. It's plurality. It's not a majority. It doesn't create precedent. All that Roberts said is, I'm voting against overturning a relatively new precedent right now, and making no commitment as to what I'm going to do in the future. And I'm not joining the opinion written by the liberal members of the court because I don't agree with the reasoning. So to describe it as a 5-4 decision, it's not. It's a 4-1-4 decision. And if Trump is reelected and makes another appointment to the Supreme Court, it will not act as precedent to stand in the way of a decision overruling Roe versus Wade. And Roberts really didn't do anything other than say that he didn't want to take steps to overturn Roe versus Wade right now. That's all he said. With that being said, we do have some questions here. Let me read one question. Why were the schools allowed to say that they must be able to fire teachers due to any means because of them being ministers when there was no evidence that they were teaching against the precepts of the religion? And aren't the schools claiming that that's what they did? Well, yes, but now I think what basically is being said is they don't have that standard. That's not the standard this court is going by. You don't have to show that the person you're discriminating against really holds a position that's key to teaching religion, and that the reason you're removing them is they don't share your religious precepts. You can simply say, we're a religious school and we don't like people based on their sexual orientation. Presumably, you could even go back to beliefs which one major religion in this country did have, and you could say, Blacks are the descendants of Cain, and we don't want them teaching our children. And I think if that were your decision to fire teachers based on that, under Our Lady of Guadalupe, you would have precedent in favor of that decision. I think now we can go ahead and move to the next video clip, which is going to talk about the decision relating to DACA.
Okay, so I'm going to share my screen better this time, and we'll go with the next video.
I also want to express my appreciation for the opportunity to be here before turning to my case, which is Department of Homeland Security versus Regents of the University of California. This case has roots that go all the way back to 1982, when the court decided Plyler versus Doe. There, Texas had adopted a statute that allowed districts effectively to bar undocumented students from attending public elementary and secondary schools. In a 5-4 decision, Justice Brennan held that the statute violated equal protection because it relegated innocent children to an underclass, a permanent underclass of illiterates. After Plyler, undocumented youth discovered that when they graduated from high school, they embarked on a transition to illegality, a world in which they could not work legally, and one in which they faced often insurmountable odds in pursuing higher education. Confronted with these stark realities, undocumented youth mobilized as the dreamers and asked Congress to provide them with a pathway to legal status. Faced with congressional inaction, in 2012, the Department of Homeland Security under the Obama administration established the Deferred Action for Childhood Arrivals Program, or DACA. DACA gave undocumented youth a temporary reprieve from deportation and made them eligible for benefits like the ability to work lawfully in the United States. 2 years later, the department expanded the DACA program and added another initiative, the Deferred Action for Parents of Americans program, which conferred similar benefits on adults with one child legally present in the United States. The expansion of DACA and the adoption of DAPA prompted a consortium of states led by Texas to challenge the lawfulness of these actions in federal court. Those efforts were successful and culminated in a 2016 equally divided 4-4 decision, a one-sentence decision by the Supreme Court upholding the lower court's holdings. As a result, after that litigation, only the original DACA program remained intact. In 2017, after the election of President Donald Trump, the Department of Homeland Security rescinded the original DACA program. This triggered a slew of litigation, and some of those cases are the basis for the Supreme Court decision this term. Now, the cases effectively focused on two key arguments. One is that the rescission violated the Administrative Procedure Act, and the other was that it violated equal protection. The first set of arguments really relate to the scope of executive power and the capacity of the courts to curb that power. The second set of arguments relate to the vitality of individual rights to be free of discrimination based on race and ethnicity. Let's start with the Administrative Procedure Act. There were several key parts of that analysis. The first is, what reasons count in determining whether the rescission was arbitrary and capricious? When DACA was rescinded, Secretary Duke provided a memorandum that focused exclusively on the arguments that the DACA program was unlawful, an analysis that was based on an interpretation offered to her by Attorney General Jeff Sessions. Subsequently, her successor, Secretary Nielsen, did another memorandum at the request of a district court hearing one of the rescission cases and added policy considerations and an account of the reliance interests of DACA beneficiaries. Chief Justice Roberts, over a vigorous dissent by Justice Kavanaugh, found that only Secretary Duke's memorandum, contemporaneous with the rescission, should be considered. Looking at that memorandum, he then had to determine whether the reasons given were sufficient to meet the Administrative Procedure Act's rationality test. And he started with the argument that the original DACA program was unlawful. Without determining whether the program in fact was unlawful, he concluded that Secretary Duke could fairly rely on the Attorney General's conclusions in that regard. This triggered a dissent by Justice Thomas, who said that the original program was unlawful and therefore necessarily the rescission was appropriate. Now, having concluded that the lawfulness issue wasn't necessarily grounds for finding that the rescission was arbitrary and capricious, Chief Justice Roberts said, we can't stop there. We have to look at what was not in the memo. And he focused on two key things that were missing. One was, in Chief Justice Roberts' view, the distinction between deferring prosecution, that temporary reprieve from deportation, and conferring eligibility for benefits. In his account, the Texas litigation really focused on conferring eligibility for benefits, but did not necessarily undercut the department's ability to defer deportation. And the Secretary's failure to engage with that distinction was arbitrary and capricious. The other thing that Chief Justice Roberts looked at were the reliance interests, not only of the DACA beneficiaries, but of institutions and organizations who invested in these young people, believing that they had protected lawful status. And the Chief Justice said that the failure to consider those reliance interests was also arbitrary and capricious. It was clear from the decision that the department had the authority to rescind the program, but it had to provide sufficient reasons. Having concluded that the rescission violated the Administrative Procedure Act, Chief Justice Roberts then turned to the equal protection arguments, and there were three key components. The first is that the rescission had a disproportionate impact on Latinos of Mexican origin. About 78% of the DACA beneficiaries fell into that category. According to Chief Justice Roberts, that was not enough to show an equal protection violation because the demographics of the undocumented population mean that any change in policy will have a disproportionate impact on this group. The second thing was procedural irregularities in the rescission. Only 3 months before, the Trump administration had said that DACA was secure. But Chief Justice Roberts said that there was nothing irregular in the steps leading up to the rescission that led to this policy shift. The final thing were remarks made by President Trump, both during and after his election to the presidency. And here, Chief Justice Roberts said that those comments were irrelevant to the rescission because they did not bear directly on the actions that Secretary Duke took. This prompted a vigorous dissent by Justice Sonia Sotomayor, who said that essentially the court had failed to look at the interaction of these different claims. For example, looking at that disproportionate impact through the lens of the remarks that the president had made about Mexicans as criminals and rapists and murderers, which suggested discriminatory animus as a motivating factor. After the case, there was speculation that the Trump administration would rescind the program again, although it hasn't yet done so. However, it does appear that the administration has not been processing applications. What are our key takeaways from this case? First, the court has some modest power to curb the executive's authority. But secondly, I think, and more hauntingly perhaps, the parsimonious formalism of the equal protection analysis reveals that this is but a hollow vestige of the clause that once inspired the court in Plyler to worry about the fundamental integrity of our democratic fabric.
Okay, well, I think, and I was asked, one of the questions that's been posed is, am I concerned about the possible death, essentially, of progressive policy at the hands of this court? And I guess I would say, you know, it's always right to be concerned about what the court may do, but this particular example, this particular case involving DACA is a continuing outgrowth of the approach Roberts took on the census case last year. You may recall that the government decided at one point to ask about citizenship in connection with the census. And the reasons proffered for it were, for asking that question, were, in the view of the courts below and in view of the Supreme Court, ultimately, simply false. The government simply lied about why it was wanting to ask that question. In the past, I think a lot of lawyers and judges would have said, well, you know, when the standard is arbitrary and capricious for the review of either a court decision or an agency decision below, arbitrary and capricious is just another way of the appellate court saying we're going to allow the agency or the government or the court below to do whatever it wants. And what Roberts established with the census case is no, if your decision is based on information that's demonstrably false, you're not going to be allowed to make that decision. And here, that concept, and there's even more teeth now to the arbitrary and capricious review standard, is if you say, well, DACA, which did two things, it made people who were here and arrived here as minors without proper legal documentation, it made them eligible for certain benefits, and that's what the Attorney General said was illegal, but it also deferred their deportation, and they arguably relied on that deferral of deportation, and that factor, and the Secretary could have said, well, we're going to end the eligibility of these individuals, the Dreamers, for benefits, but it's a separate question of whether or not we're going to continue to defer deporting them from the country. And instead of doing so, the Secretary simply arbitrarily and capriciously tried to rescind the entire program. And what's really marvelous about this ruling is it reflects the Supreme Court requiring the government to be more transparent about what it's doing, to be more honest about what it's doing, and to do it in a way that's open and transparent and logical. And if this continues to be jurisprudence that Roberts can continue to develop with the support of other members of the Supreme Court, it holds out a lot of hope for conforming government agency decisions to a higher standard. So I think it's a good thing. I don't see any other questions on this issue, so I think we can move to the.
You were going to talk about Kate Shaw.
Oh, we were going to talk here about Trump, and we were going to talk about Trump versus Vance and Trump versus Mazars. Yeah, and let me just say one other thing briefly on the DACA case. One thing you'll be struck by if you read some of the dissents on this case, particularly Thomas's dissent, is the simplicity of it. The argument seems to be, well, the program's illegal. That's all the agency needs to do is find the program's illegal, then it has the right to end it. It doesn't have to make any sort of balanced consideration. That, I think, is the old traditional view of arbitrary and capricious, and that standard is arguably gone. The Mazars and the Vance cases, Trump versus Mazars and Trump versus Vance, deal with cases where Congress and a district attorney, Vance, a state district attorney in New York, are trying to get private records, arguably private records, of the president for various purposes. What Mazars held is that a congressional subpoena needs a legitimate legislative purpose. And it cited the Nixon case as setting this standard. And it rejected Justice Thomas's minority view, which I think would have resulted as a practical matter in overruling the Nixon decision. It rejected his view that simply, and Alito's view as outliers, that simply you cannot get any documents from a president at any time. Now, will Congress be able to show a legitimate legislative purpose for the documents it wants to get? I don't think the Supreme Court decided that. Therefore, I think this case has gotten a lot of publicity without really knowing what its end impact is going to be. And certainly it's not going to result in documents being available before the November election, I don't think. Similar issues came up in the Vance case, except in the Vance case, it's more removed. Unlike Congress, which has to show a legislative purpose, in the Vance case, it has to show, the state attorney general simply has to show whatever the normal standards are for a state district attorney to subpoena private records of a president. And the case that was discussed in great detail, the precedent, all involves the treason trial of Aaron Burr and efforts by prosecutors at the time to get records from Thomas Jefferson. And Jefferson ultimately agreed that he had to provide the records, but expressed the concern that if too much of his time is taken up looking for the records, that it would interfere with his duties as president. And so a sort of compromise position had to be taken to some degree. And Thomas emphasizes the idea that Trump has such enormous responsibilities that to call upon him to gather together his private records to respond to a state criminal investigation is just inappropriate and shouldn't be allowed to happen. Factually, one might question whether a president with large amounts of time in his diary, vaguely described as executive time, whatever that means, a term not used by any prior presidents, and who is visibly seen spending large amounts of time on golf courses, one can question whether really the job really is consuming all of his time such that he can't respond to a subpoena, particularly since, just like everything else, he can delegate the response to the subpoena, just like he delegates a number of his other responsibilities. If you read Thomas's opinion in this case, you'll be sort of amazed how detached from reality it is, how it seems to be enmeshed in the details of Jefferson and Burr. And I think it's one of the many decisions where Thomases want to cite cases that are 300 and 400 years old as though they are valuable current precedent. Sometimes they are. In this case, I think one can make a plausible argument that at some point, depending on how many successive subpoenas Trump is faced with, it might be an undue burden on the president. But factually, it seems unlikely that the facts will come out that will show these subpoenas to be an undue burden on the president later. Now we're going to go into video number 4, which I think, as you'll hear when I discuss it at the end, it is one of the things that I would say the decision that is singularly probably one of the most optimistic, one of the best decisions out of this Supreme Court in terms of what it means for the future. So with that, let's go into the 4th video clip.
And if I can suggest one potential theme or focus that would be useful to consider or examine from the court's past term, it might be conservative theories of interpretation, both textualism and originalism, both of which have played major roles in the court's rulings. One of the things that was particularly noteworthy about this term is the disputes among particularly the conservative justices about how to properly apply those theories and what it means to apply those theories. I think an important subtext underlying many of the court's opinions, and one of the major questions that many of the court's opinions raise, is whether these theories actually do meaningfully constrain judicial decision-making in any way, or if instead the legal realist critique that it's all just politics, these are all just after-the-fact rationalizations for what the judges want to do as a matter of personal politics, has some weight. And one question of personal interest that they raise for me is what role, if any, the barking dog canon has, also sometimes referred to, or close variation, is the no elephants and mouse holes canon, in light of the court's embrace of, in particular, textualism. So I'm going to begin today by talking about the Supreme Court's interpretation of Title IX of the Civil Rights Act of 1964 and its ruling in Bostock. Justice Gorsuch and Roberts joined together with the liberal justices to draft the majority opinion, focusing primarily on the language of Title VII, which says it is, in relevant part, it is unlawful to discriminate against any individual because of sex. And the main question the court was presented with is, does this statute prohibit employers from discriminating against homosexuals and transsexuals on account of their sexual orientation or their gender identity? And Justice Gorsuch's majority opinion essentially said, of course it does. The opinion reasons that it's literally impossible to talk about someone's sexual orientation or sexual identity without considering sex and without taking their sex into account, and treating employees differently based on their sexual orientation or sexual identity unavoidably constitutes a form of sex discrimination. He emphasized that the ruling was limited in that it was not at that time addressing bathroom policies, locker room policies, dress code requirements. However, Title VII's broad prohibition against sex discrimination included protection based on sexual orientation and sexual identity. The majority opinion was strident in saying it didn't matter whether the enacting Congress anticipated or intended for that because of sex language to extend to sexual orientation and gender identity. It didn't matter whether they anticipated that it would. The majority opinion instead said it was bound to apply the ordinary understanding of the text. Justice Alito's dissent accused the majority of sailing under a textualist flag in what perhaps might be the first accusation of textualist piracy in a Supreme Court opinion. But Justice Alito basically said that rather than applying the ordinary meaning of Title VII's language, the majority was really updating the meaning of the statute in accordance with its own perception of modern values. Justice Alito's dissent contended that sex means biological male or biological female, and that sex is a distinct concept from sexual orientation and gender identity. He argued that the majority's reasoning depended on labeling, that if one characterized what employer did as firing a gay man because he's attracted to another man, then he would be deemed to be fired on account of sex because a woman wouldn't be fired for being attracted to another man. Yet if one characterizes the same employment action as an employer firing a gay man because he's attracted to someone of the same sex, then he wouldn't be fired under that account on account of his sex, because a woman would also be fired for being attracted to someone of the same sex. And so Justice Alito argued that if an employer is applying essentially the same policy to people, regardless of whether they're men or women, then it doesn't, the employer's actions don't violate Title VII. Justice Kavanaugh issued a separate dissent, but he approached the statute in a fundamentally different way than either the majority opinion or Justice Alito's dissent. Both of those previous opinions essentially broke up the wording of Title VII. What does it mean to discriminate? What does the phrase on account of mean? And what is sex? And the majority in Justice Alito's dissent essentially differed on the meaning of that last word. What is sex? Justice Kavanaugh, in contrast, said we can't break up the statute into each individual word, but rather we have to take a larger unit of analysis. We need to ask the phrase discriminate because of sex. What is the ordinary meaning of that phrase? Particularly at the time the statute was enacted, if you talked about discriminating because of sex, would the ordinary listener think to themselves, you're discriminating against someone because they're a man or because they're a woman? Or instead, would the ordinary listener at the time think to yourself, oh, that could mean gender identity discrimination. That could mean sexual identity discrimination. And so what Justice Kavanaugh's ruling said is, focusing on the overall phrase in the statute, we need to focus on the ordinary meaning, not of each word in isolation. He rejects what he characterizes as an overly literal approach, what is sometimes described as a wooden-headed approach, focusing on the literal meaning of each word in and of itself. But rather, he says, if we look at the ordinary understanding of the phrase as a whole, discrimination because of sex at the time, as well as today, is generally understood, he argues, as a distinct concept from discrimination on account of gender identity or sexual orientation. One major question that the case raises is, to what extent, if any, is it appropriate for a textualist to consider what is sometimes referred to as either the barking dog canon of statutory interpretation or the no elephants and mouse hole canon of interpretation? both of these canons are variations on the same theme of, if something is important enough, if a statute truly correctly interpreted extends to a very controversial, a very important, a very major issue, would we expect to have some indication somewhere either in the statutory text or the legislative history or the overall circumstances surrounding the statute? Would we expect there to be some indication that, yes, this statute was in fact applying to this controversial area, that the statute was applying to this major issue? The Supreme Court had applied that canon in past cases like FDA versus Brown and Williamson, where the court rejected the notion that at the time the FDA had authority to regulate cigarettes, saying, if Congress had intended to regulate the tobacco industry, that has a big enough impact on the economy that we would have expected some indication in the legislative history. My time is just about up, so I'll just briefly mention one of the other really important pairs of cases from the term, Chiafalo versus Washington versus Colorado Department of State versus Baca. The Supreme Court also said, we're going to apply the text of the Constitution to say that, yes, states may regulate presidential electors, may regulate how they cast their electoral votes, may bind them to cast their electoral votes in accordance with the outcome of the election within that state. The framers' unexpressed intentions about how the electoral college would work, or their understanding of how the electoral college would probably play out, isn't binding. It's only the text.
Okay, well, let me explain why I think this is such an interesting case and what it really means. At the end of the day, in this case, Gorsuch actually stood by a concept that all the other conservatives claim they're standing by, which they use fancy labels for, called textualism and originalism, which are just, how are those different? Well, just being a trial court judge, my expression for it is a little more plebeian. It's called plain meaning, which is how contracts are interpreted and how statutes and constitutions are supposed to be interpreted as well. And what plain meaning means is it doesn't matter what you thought at the time. If the words are not ambiguous, you interpret the words according to their literal meaning. And in opposing, and so Gorsuch says, for example, if, it was, I commend his opinion to you because it's a delight to read, because it's so simple and it stands by concepts that are so basic to statutory, contract, and constitutional interpretation. For example, if an employer fires a lesbian woman because she's attracted to a woman, you may well say, well, she's being discriminated against because she's gay, but she's also being discriminated against because she's being treated differently because of her sex, because a man attracted to the same woman wouldn't be fired. And it doesn't matter that there are multiple discriminatory causes involved here. As Gorsuch points out, you have all you need to show, typically in a case like this where the statute broadly invokes but-for causation, all you need to show is that the impermissible discrimination is a contributing factor. And that's well known in many cases where plaintiffs seek recovery. So the frantic conservatives thinking they've got some sort of monopoly on plain meaning, which they've relabeled, and they're really the ones wearing the pirate flag in this one. You can read Alito's opinion and he is just unhinged. And I think the reason he's unhinged is because Gorsuch's opinion is not only clever, but it accurately describes what the law should be if you apply the standards that all the conservatives themselves say they're applying. Now, Kavanaugh, as the professor pointed out, Kavanaugh said, well, no. You look at the words not by their individual meaning, but you look at them in a group and determine what they mean as a group. Well, what he's saying, and nobody in any of the opinions uses this word, but what Kavanaugh is saying is that sexual discrimination is an idiom, kind of like raining cats and dogs, where if you look at the literal words, you can't discern the meaning. An idiom is defined as a group of words established by usage as having a meaning not deducible from those of the individual words. That's just the dictionary definition. But nobody said that there's an idiom at issue here, because there isn't. It's just nonsense. And so what has happened in this case, and which shows I think, great deal of hope, where if you're in front of the Supreme Court defending a statute, that the literal meaning of the statute is very broad, even though it may not have been applied that way for an extended period of time. If the literal meaning of the statute is very broad, then we can still have that literal meaning apply. And I thought it was a very insightful, discussion. I don't see any questions on this subject. We'll go back. We have some other questions on some of the ones that came up earlier, and we'll go back and try to cover those later. But I thought the Gorsuch opinion here and the heated, I would say, anger or vitriol with which Gorsuch was attacked by his own fellow conservatives was very interesting. And it'll be interesting to see if it impacts the interpretation of other statutes that may come before the Supreme Court from time to time.
Okay.
Let's go with the next one.
Okay.
Yeah, that's exactly where I wanted to go, is to talk about the shadow docket, because, when you read the end of term reviews, they tend to focus on the cases that get decided by decision, the Title VII case, the abortion case, the DACA case. And yet so much is happening now, coming up on emergency petitions. And so maybe, Ariane, can you just describe, let's talk about what we saw with the death penalty, and then I want to turn to Kate and Michael on the voting questions. How is this shadow docket working, and what patterns are we seeing there?
Well, the thing is we don't pay as much attention to it, ergo that's why it's the shadow docket. But if you look at the federal death penalty case, and I'm intimately familiar with it because I was on vacation, and twice in a row, the Supreme Court came out with opinions at 2 a.m, clearing the way for the federal death penalty. Those shadow docket items have got to be added to the ledger here. And also, I was thinking back at the extraordinary year that Justice Ruth Bader Ginsburg has had. And now, of course, we know in retrospect that she had gotten that other diagnosis in February. So I was looking back at sort of some of the things that she's written. And when she wrote early on in dissent in that Wisconsin voting case, where she just took apart the majority, accusing them of so narrowly, or saying that they were ruling so narrowly and totally disregarding COVID, she was at her top there and her most angry. And those are the kind of, again, that docket, which doesn't often get weighed on the same balance as the opinions, that's got to be looked at this term, particularly for those who are continually pointing to the liberal wins here, because that's not the case in the voting and in the death penalty.
I want to come back to Justice Ginsburg's health and the future of the court as we get closer to the end of this program. But let's continue on the shadow docket. And again, just for those who are not familiar with the term, what we're talking about are cases that are not coming up after they've been finally decided in a lower court, like a state Supreme Court or a court of appeals, but instead coming up on an emergency basis. And it could go from a trial court to the Supreme Court within a matter of days, for example, as Ariane described on death penalty issues. But a place where we've seen a lot of cases has been related to voting. And this year, we're fortunate to have 2 election law experts on this panel with me, so it's nice to have some company. So let's ask Kate and Michael. Start with Kate. I have a question here from Jonathan Adler about the Purcell rule. And does this mean that voting rights always lose 5-4? I mean, what are we seeing there? And start with Kate.
Sure. Yeah. So the Purcell rule or Purcell principle is this sort of ill-defined rule the Supreme Court has announced from a case out of Arizona, I think it was, that basically says federal courts should not disrupt election procedures on the eve of an election. And what an eve of an election is and what disruption entails, I think are fairly underdeveloped. So the decisions in this area, such as they are, tend to come up, as Rick just suggested, in this emergency posture. So the court will either write a very rushed opinion. I think Ariana's exactly right. Ginsburg wrote a quite impressive dissent in the case in April, in which a 5-4 majority of the court put on hold a Wisconsin district court order that had, I think, fairly modestly, although I think Michael and I might disagree about this, expanded access to absentee voting in Wisconsin. This is April, remember, so we are at the apex of, I don't know, the first phase of the first wave of the pandemic. And a lot of people in the tens of thousands, or at least 10,000 who'd requested absentee ballots had not received them. And there were declarations from state officials making clear they would not receive them. And so a federal district court took a look and said, we are going to have an unconstitutional infringement of the right to vote if we don't take some remedial steps. And those included extending absentee voting deadlines. And the court 5-4 on the eve of the election, maybe a day, maybe 2 days before, put that district court order on hold, restoring the earlier absentee voting rules. And in some ways, that feels like much more of a violation of Purcell than simply allowing to stand the relief that had been ordered by a federal district court and affirmed by the Seventh Circuit. Something similar happened, although without an opinion, in Alabama just a few weeks ago, in which an Alabama district court had also directed the expansion of absentee voting to account for pandemic conditions. And even, I think, a more modest way than a Wisconsin district court had. The 11th Circuit, there's some backstory here, but the 11th Circuit put this on, actually, I can't now remember if the 11th Circuit, I'm thinking of the Florida case. In any event, the Supreme Court put on hold, I thought, a very careful district court opinion, so that this, these restrictive absentee ballot access rules, again, were in effect for the July primary in Alabama. There's a Florida case as well you haven't asked about, Rick, but that's not a pandemic case per se, but also the Supreme Court, acting in ways on the eve of or very close to an election in a consistent direction of thwarting rather than facilitating access to the ballot.
Michael? Oh,
I
you're
think
muted.
when you're talking about the Purcell principle, I do think that it's helpful, as Kate had suggested, to distinguish between emergency cases versus other cases. Right? In an emergency case where there's some sort of unexpected problem, whether it's a pandemic, I'm in Florida, it might be a hurricane, it often is a hurricane. If there's some sort of unexpected last minute problem that creates last minute substantial burdens to vote, that's materially interfering with the election, that's threatening to disenfranchise people, I think that it's inevitable that there's going to be some changes. Some states have laws that give election officials themselves power to make the adjustments, the modifications necessary to be able to facilitate voting despite these types of barriers. In the absence of those types of laws, then you just have the court as the ultimate fallback to adjudicate those types of cases as a matter of constitutional law. I think that those cases are different from other election litigation where more or less the challenges could have been brought at any time. You are challenging laws on their face or laws as they're applied to particular groups over and over, and where it's more random in a sense when the court winds up issuing its ruling. I think the Purcell principle was certainly crafted in the latter category. I think it's much more naturally applicable to the latter category where, and obviously Rick has written about this, at an absolute minimum, just when courts do their traditional equitable balancing about how to grant relief in order to enforce constitutional rights, I think it's appropriate for the court to take into account timing considerations, whether the rules of the election are being changed close to the election, whether there's adequate notice to voters, whether election officials themselves are going to be able to be trained across the jurisdiction to implement them consistently. In an emergency circumstance, in contrast, there have to be last minute changes. It's inevitable that things aren't going to go the way that everybody had planned. And so I think categorically the Purcell principle is less applicable in the emergency context.
But the court doesn't seem to agree on that point, right?
Right.
So that brings up a question of, what are we going to expect in 2020 in terms of the court's involvement in the election? I don't know if any of you have any thoughts about that, but I have a few questions here about that. Do you think that Trump versus Biden is going to make it to the Supreme Court? Or maybe no one wants to weigh in on that.
I want to hear what you think.
Well, I think that the biggest variable is whether or not the election is close. And if it's a close election, then I expect the Supreme Court will play some role in it. But we'll see.
Well, whether or not the Supreme Court plays a role in the Biden versus Trump election should be determined by whether or not there's a substantial federal question, not by whether or not the vote is close. But of course, in many respects, one could say that the Supreme Court made a serious mistake in Bush versus Gore 20 years ago when it interfered in the election. People forget that we don't really have a national election for president. We have 50 elections in each state for electors. And unless the way the state is conducting its elections somehow violates constitutional or statutory rights under federal law, the state should be allowed to have its processes be complete. In Florida, there was, as Justice Stevens said in Bush versus Gore, there was no federal question involved. It was simply a question of how Florida was going to conduct its recount. The recount didn't really impinge on equal protection, and it was a question of how quickly the recount could be completed, and there was ample time to complete the recount, and it was unnecessary and unproductive for the Supreme Court to be involved. And I think if the Supreme Court makes the same mistake in this election that it made 20 years ago, it will further degrade what little remaining reputation it has for being unbiased politically. And so hopefully it will go back to the standard, which is you don't review decisions by state courts unless there is a substantial federal question involved. But I think the speakers also spoke eloquently to the concept that there are a number of times when the Supreme Court makes decisions, it doesn't actually issue a written opinion, but it makes decisions that have a very significant impact simply by virtue of how the vote would be conducted. Someone asked me a moment ago, and then we'll go on to the next clip, but someone asked me a moment ago, I think it was with respect to the Bostock decision, the Title VII gay rights decision, was I surprised by Gorsuch? Yes, I can't say I'm a student of the Supreme Court justices, so I'm surprised when someone falls outside their sort of standard mold. But what was nice about the language of the opinion is it also was very broad and very sincere in a way that I think that there's a wedge that can be developed there to pry away from sort of the traditional conservative approach, an approach that would preserve at least statutes that have literal language that's very broad and helpful. So I think that's still the case. I think we do have a danger of this court going forward, though, both on on the issues of voting rights. We have a danger with it going forward that it will not learn a lesson from Bush versus Gore and will continue to simply ride roughshod over state court decisions, even though it's really not appropriate for the Supreme Court in almost all circumstances to be interpreting state law issues as opposed to federal law issues. That being said, let's go to the next video clip, which, among other things, deals with the influence of John Roberts.
Let me turn back to the broader question of John Roberts' influence. I want to start with Erwin on this question. What does it mean for John Roberts to be the new center? Is stare decisis doing the work here? Some of the questions that have come in have suggested that John Roberts is just trying to stall things during an election year to help the political party that he came from. I know you're not a psychoanalyst, but what do you think is going on here?
And I'm very uncomfortable guessing as to what his motives are. Is his motive to preserve the legitimacy of the court? Is his motive so as to make the court less of an issue for the November election? Or is he just calling them as he sees them? I don't find the discussion of motive very helpful because there's no answer to it. What does it mean that he's the swing justice? Well, when Justice Kennedy was the swing justice, lawyers knew that they had to prepare their briefs and arguments in many cases to get Justice Kennedy's vote. Or I remember when Justice O'Connor was the swing justice, commenting in a case that I had in the court that my brief was a shameless attempt to pander to Justice O'Connor.
If I could have, I would put Sandra Day O'Connor's picture on the front of my brief. Now it's John Roberts who plays that role. I think what's most interesting about Roberts this term is how he had voted in dissent in Whole Woman's Health to uphold the Texas law, but voted to strike down the Louisiana law. In the gay rights cases, the marriage cases, Windsor and Obergefell, Roberts dissented. In fact, the only dissent Roberts has ever read from the bench since coming on the court in 2005 was his dissent in Obergefell. But he was in the majority with regard to the gay rights case this term. I don't think John Roberts is going to be a progressive judge. He's not going to be a David Souter even. Overall, he's conservative. Remember, he's the one who wrote Shelby County with regard to gutting the Voting Rights Act. He's the one who wrote Parents Involved, strongly against affirmative action. Prior to this term, he had never voted to strike down any abortion restriction. But it's clear he's now the median justice ideologically. And I think what's most important then is how lawyers are going to write their briefs and pitch their arguments with him in mind.
And let me just follow up before I turn to others. It seems like one of the things we've seen is on certain issues, it's not just Roberts who's in play, it's also potentially Gorsuch and maybe Kavanaugh in terms of the way he's written some of his decisions. And maybe you can answer this maybe in reference to McGirt.
I think that Gorsuch and Thomas have more of a jurisprudence that they follow and will go even when it seems to lead to absurd conclusions, like the Establishment Clause doesn't apply to state and local governments. Gorsuch's majority opinion in Bostock was following his methodology where he thought it took him. In terms of McGirt, it's a fascinating case because it isn't about methodology or jurisprudence. This is the case where the Supreme Court held that a large part of eastern Oklahoma was tribal land, and under a federal statute, under a treaty, a tribal member could only then be prosecuted in federal court, not in state court. I would explain this based on Neil Gorsuch's opinions on the 10th Circuit, that he tends to be a judge and a justice who's very protective of Native American rights. Read the last paragraph of Gorsuch's majority opinion in McGirt, which is very much about how the United States has to keep its promises to the Indian tribes.
Others want to weigh in on this? Not on McGirt in particular, but just on Roberts' position on the court and what we're seeing?
The only thing that I would add is that a swing is not a swing is not a swing, that there's very different kinds of swing justices. And I think of Justice Kennedy as having written in a sort of a broader swath, like, elaborate prose and broad principles. And so you felt that the swing was capacious. But I think that some of the methodological jurisprudence here is so strict and so narrow that threading the needle to get to the swing is a lot trickier, just because I think the decisions are so much more narrowly framed. And very often they say, we're not concerned about some of these things. We're just concerned about these very narrow matters of text or formalism, or, it's just not as capacious a swing to me as some of Justice Kennedy's opinions were.
Let me follow up on that because, one theory I've heard is that, it's a lot of these decisions and the way they're written are very tactical. So Bostock, the opinion that Michael talked about transgender and gay discrimination, is actually a Trojan horse to later attack affirmative action through a very literal reading of race. I mean, do you think the justices are taking the cases as they come one at a time, or are they thinking strategically in terms of building on the precedents that they create?
Well, I assume that they are thinking for the longer haul, and they grant certiorari with an eye to how these coming cases will build the jurisprudence. I do want to say that I'm not sure that Bostock actually lays a foundation for overturning affirmative action in higher education, because one of the things that it suggests in dictum is that organizations should have autonomy, and part of that autonomy may be that they can discriminate when it fits their fundamental mission. And if you think about the Bakke case, it was really rooted in the institutional autonomy of colleges and universities and their ability to, for pedagogical reasons essential to their mission, to use preferences in the admissions process. And so it seems to me, unless you're going to say religious organizations' autonomy is so distinct from every other form of institutional autonomy that it gets a unique treatment, that it actually contains potentially a very different kind of Trojan horse with respect to affirmative action.
Oh, interesting. Other thoughts, Kate?
Yeah, can I just, it's just a general kind of thought about John Roberts. It connects a little bit the Rachel and Irwin's earlier remarks connecting, which I think, of course, they are connected, the DACA case and the census citizenship case, but also to a third Roberts opinion from the term before, right? The travel ban opinion. Because I wonder, as I've thought about, the evolution of the Chief Justice, I am definitely not of the view that we have a Justice Souter in the making, but I wonder whether, so of course, the chief writes the opinion for a 5-member court upholding the third iteration of the travel ban, and then the opinion for a different 5-member court striking down the citizenship question and the DACA rescission. And does the John Roberts of the year 2020 come out differently or the same in the travel ban case? And I don't really know what I think the answer to this is. I mean, I think it's important that it was the third iteration of the travel ban. The first, I don't know whether John Roberts 2 years ago or now would have endorsed the constitutionality of the first iteration of the travel ban for some of the kind of, process reasons that Rachel identifies with DACA. Although, of course, that's a constitutional case and it's presidential action as opposed to agency action where you have the kind of filter of review under the Administrative Procedure Act, right? There is no explicit prohibition on arbitrary and capricious presidential action, although I think it's probably implicit in the Constitution. And so I guess I just don't know whether there's an increased skepticism about too deep a deference to executive power, whether we're talking about the president or an agency, or whether it's just the differences in the legal standards in the cases explain the divergent outcomes. But it seems to me there's something in those 3 cases and John Roberts as the deciding vote in each of them that is significant and worth considering together.
Yeah, it's hard to think about the counterfactual when we don't know, would a Jeb Bush administration, if it decided to rescind DACA, have done a sloppy job? I'm guessing not. And then what would have happened and where would John Roberts have been? Erwin, you had another point?
I think Kate raises a good point, but it also goes to the difference between the travel ban case 2 years ago, which was a constitutional case, and the census case in DACA, these 2 terms, which is the Administrative Procedures Act case. And I think it reflects something important about John Roberts. I think he's a minimalist, and I think he wants to, when possible, go step by step. Both in the census case and in the DACA case this term, he was clear that the Trump administration could do this, but it had to follow proper procedures. And so it was a limited ruling of the court. With regard to the travel ban case, it was a constitutional ruling. I'd like to believe that John Roberts has changed his mind in 2 years, would come out differently on it. I don't see any indication of it. I think he's still somebody, when the chips are down, is going to come down on the conservative side.
All right, we only have about 10 minutes left, so I want to turn to the future of the court. And I want to start with Ariane. And you had mentioned Justice Ginsburg's illness, which unfortunately has returned, her cancer. What do we think the impact of this illness is going to be in the short term on both the Supreme Court and the politics of the Supreme Court as we enter into the presidential election year?
Just before I get to this, I have to confess that I couldn't sleep last night, and I was thinking in terms of Roberts and Roberts' role right now, and Roberts' 2-step that we saw in the Trinity Lutheran Espinoza. And then I was thinking to myself, if we were to get a vacancy this term, or if we were to get, or if Trump were to win and get another person on the court, all of this John Roberts that we have all built up and we've all talked about looking down the road and where he's going and how he moves, it all goes away because he's totally, if there were 5 conservatives there, suddenly he has very quickly lost that seat, which I think is kind of fascinating to think about it. And as far as Ruth Bader Ginsburg, I think what's interesting there is this time around, she is, of all the justices, she's been the one who is the most honest and quick with her diagnosis. We've gotten a few in the last several years. When you think about John Roberts just a few weeks ago, when he fell on his head, was bleeding, was taken to an ambulance to a hospital. And the only reason that the public knew about it was because there was, I think, a tip to the Washington Post. That's a totally different story. So now we look at Ginsburg's health. Nobody's been able to see her, but we have CNN reported earlier this week that already Republicans on the Hill were sort of being asked if they'd have hearings even after November. And some of the Republicans were saying they might, and Lindsey Graham didn't say anything, and Grassley said he wouldn't. So it's just extraordinary to think to think of that playing out. That changes things just so radically from the way they've been done.
So, and just for those who are not familiar, the unspoken predicate here is that when Justice Scalia died suddenly, and it was the last year of Barack Obama's presidency, he had nominated Merrick Garland of the Court of Appeals to be on the Supreme Court and did not get a hearing under the so-called Biden rule that you don't hold hearings in the last year. And now we're talking about not only holding hearings in the last year, but potentially after there could be a Trump loss and a Senate loss, which would be quite extraordinary. Other thoughts on what to look for in the Supreme Court term ahead and about the Supreme Court more generally, that we are so, our jurisprudence is so dependent upon the health of octogenarians. I mean, what does that say about how we make law in this country? I don't know. Michael, do you want to weigh in on some of this?
Sure. I mean, I think one of the biggest impacts that we certainly saw it in the 2016 presidential election cycle. I expect that we will see it this election cycle, is that the Supreme Court becomes a campaign issue, right? I mean, candidates run on, in some cases, right, overturning particular rulings, defending particular rulings. Rather, if anything, it's almost right inverse constitutional interpretation, right? Justices are appointed to the court not because of how they're expected to vote in particular cases. Presidential candidates are voted upon by and seek to persuade voters to vote for them based on the justices who then they'll appoint. So I think that particularly as greater awareness, there's greater public awareness of both Supreme Court rulings, of the role that politics is playing in the Supreme Court selection process, right? Obviously, President Trump last time around released a list of people who he said would be on his list of potential Supreme Court nominees. I think it's going to put a lot of pressure on this, what you had previously been, or at least is certainly, right, many of us teach in law schools, are the distinction between just the purely political process versus the judicial process of, right, interpreting a statutory text, interpreting a constitutional text, which is supposed to be largely different.
Other thoughts on what to look for in the next term? Are there any blockbuster cases that are queued up? Erwin?
Sure, I want to go back to what I was talking about earlier in terms of religion. There's a very important case, Fulton versus City of Philadelphia. It involves whether Philadelphia can refuse to allow a Catholic social service agency to be involved in adoptions and foster care placement because it wouldn't place children with gay and lesbian parents. The Third Circuit ruled in favor of the city. The church sought cert, and one of the issues presented is whether the court will overrule Employment Division versus Smith. That's a 1990 case that says that there's no special exceptions for religions from general laws. I think a court that wants to provide much more protection for religions to discriminate, religions to be able to make the choices they want, will overrule Employment Division versus Smith. And the other, of course, is California versus Texas, which puts before the court again the issue of whether the Affordable Care Act is unconstitutional. The Supreme Court declaring the Affordable Care Act unconstitutional would mean that about 25 million people would lose their health insurance. I think it's an unusual argument. It's that Congress rescinded the individual mandate, the requirement that people have to pay a penalty if they don't have health insurance, and that Congress choosing not to have this makes the entire Affordable Care Act unconstitutional. I don't get the argument because, of course, Congress could have passed the rest of the Affordable Care Act without the individual mandate, but the Fifth Circuit accepted that argument. It would invalidate the Affordable Care Act, and it's now back before the Supreme Court.
And if I recall, there were some cases this year where the justice wrote about severability, which would seem to suggest that the court is unlikely to rule in that way.
Right. Yeah. Of course, severability is the question of would Congress have adopted this statute without the provision that's declared unconstitutional? What's different here is Congress itself repealed this provision, but refused to repeal the rest of the Affordable Care Act. Doesn't that give us the clearest possible indication that Congress wanted the rest of the Affordable Care Act to survive?
And Ariana, I want to ask you about abortion cases, since this was not the only one in the pipeline. Is it going to go the way of guns, where we got 10 search denials and the court just said it's just staying out of this area, or which we didn't get to talk about today.
That we could spend a whole 50 minutes on the Second Amendment there.
But what's coming up in terms of abortion?
Well, what's interesting is that, as I talked about, Robert's decision comes down, and then, as happens every term, after a big case comes down, they usually send, they've been holding other cases, but particularly two cases, and I don't have them in front of me, they send it back to look at.
Indiana, I believe.
And it's the ultrasound, I think. I can't remember if there's one or two, but there was a flurry of cases that went back. And I think that is exactly where we'll see sort of the heart of where the court is going on abortion. And I think there, Roberts is going to be quite different than he was in this particular case. And just on the severability question, I was struck in the CFPB opinion. I think it was out of nowhere, it seemed Kavanaugh had some very strong language about severability. And I think that I definitely highlighted thinking about the ACA case next term, because boy, he sure seemed to be sending a signal there that there wouldn't be severability.
Kate, I'll give you the last word because we're almost out of time. Please.
Just in terms of what's coming down the pipe on the abortion question, I think that it's pretty clear the court is not going to take up one of these bans or near bans that a lot of states post confirmation of Kavanaugh quickly moved to enact. I can't imagine that the four conservative justices would be confident of Roberts' vote to uphold one of those bans or near bans. And so I expect it will be quite some time, barring some change in composition on the court, before this kind of big frontal question of the future of Roe and Casey is before the Supreme Court.
Yeah, so it sounds like when John Roberts is in the driver's seat, we kind of know the general direction that he's going in. It's a question of how much he wants to step on the gas.
I want to talk, I've got some good questions here I want to read and discuss, but I wanted to talk briefly about the McGirt case, which is the case where an opinion by Gorsuch resulted, the opinion of the court resulted in much, if not most, of Oklahoma being held to be part of Indian reservations. And I think what's kind of interesting about the case is, again, it's a reflection that at least in Gorsuch's case, he takes principles of statutory interpretation very seriously, in the sense that the argument against the decision was, well, the state, didn't treat these areas as part of quote unquote Indian country. And everyone recognized they weren't part of Indian country, and we've all behaved that way for a long period of time, and Congress took away various powers from the tribe. And so therefore, and it would be really difficult if we follow this rule that the Indian reservations still exist. And the way Gorsuch dissected that, which I thought was very interesting, is he just went through and said, look, yes, Congress has the power to abrogate treaties with the Indians. The Constitution gives Congress control over relations with Indian tribes, not the states. Whatever the state did doesn't really carry any force whatsoever. Yes, Congress allowed Indians to sell property within the reservation to others, and they have title, and that's proper, but that doesn't mean there's an end to the reservation itself. Yes, Congress restricted the functioning of the tribal governments, but that also doesn't end the Indian reservation. If you want to end the Indian reservation, you have to do what you did in other cases, is you have to pass a law actually saying that you're ending the Indian reservation. So Congress has the power, but it can't simply exercise the power by implication. It has to exercise it explicitly. And I thought that was very interesting. I'm left with a lot of foreboding about the Affordable Care Act. It's concerning because the current attack against it is sort of a statutory interpretation issue. And it's sort of the argument of, well, part of it was declared unconstitutional, the individual mandate, and this is how the argument would have to go to be a winning argument, and Congress would have never passed it without the individual mandate. And therefore, the entire law should be struck down. Not at all. I mean, as Chemerinsky said, we have the evidence of what Congress would have done in the fact that Congress refused to repeal it. There's another question here. What exactly is meant by the terms conservative justices and liberal justices? Do those terms refer to their political party affiliations, or that of the Senate that confirmed their appointments, or does it refer to the way they interpret the Constitution, or something else altogether? Well, I always try to answer every question as best I can. So the answer to this question really, I think, is yes. It's one of those things or all of those things or many of those things? I think in the past, a lot of lawyers and judges would have said the distinction really is conservative judges, at least in theory, are more respectful of case law precedent, traditional interpretations, and are less inclined to depart from them except for compelling reasons. But by that definition, today's liberal justices that we think of as liberal are really more conservative than the conservatives because they're less inclined to depart from precedent. They're less inclined to abandon traditional interpretations. Now, I think what Thomas would say is, well, I'm not abandoning traditional interpretations. I'm just digging deeper for them. Instead of going back 50 years or 100, I'm going back 300 to 400 years. And, you know, I'm abiding by what the true tradition of this country was as established by the founding fathers in the late 1700s, when the phrase all men are created equal meant all white men with property are created equal. And I guess that's the distinction. And I think I think what we really have now is we have a collection of judges, some of whom I would call moderate, some of whom I would call liberal, some of whom I would call conservative, but most of them that call themselves conservatives are really reactionaries. They favor considerable change in legal doctrine and considerable disrespect for precedent and traditional rules of law to advance a political agenda. And so you think of people like Thomas, who thinks that the Bill of Rights doesn't even apply to states, and now he's got support for that. You know, that's the kind of thing I think about when I think about a justice who I would label as reactionary and not really true to his oath to uphold the Constitution and stare decisis and case law and precedent. Another question here. My UK friends are really confused by our referral to judges as liberal or conservative. It is their opinion that judges are supposed to be independent of those terms and merely guided by adherence to the law. I should call it the independent interpretation of the law, devoid of political influence. I think that's right, and that's the tradition, at least in theory, that we evolved from, and that has been attacked by, notably, more so by groups on the right than by groups on the left. The Federalist Society has an agenda with its approved list of people for judges that is designed to get appointed as judges only people who fit the political agenda of the Federalist Society. There is no corresponding organized group on the left. So, but I think the confusion by this questioner's UK friends is a justified confusion in the sense that we have departed from the English tradition of independence of the judiciary to a considerable degree. It's been degraded. And I agree with the comment of another questioner that when we have the interpretation that judges have particular political backgrounds that are governing their decisions, it is a real danger to the role of the Supreme Court. Now, in fairness, I think there are judges, and I think Chemerinsky brought this out, you know, judges thought of as either conservative or liberal, who actually have principles of law that they follow and recognize that outweigh their political, or may outweigh, at least in some cases, their political preferences. And I think Gorsuch may turn out to be one example of this kind of justice. I know in the past there were others that fell into it as well, and it would be nice if they were a majority on the court, but that's not the current status of things. It's also, I want to give a brief comment to there was a case, actually it might have been a set of companion cases. There was a case that just in a nutshell, Chiafalo versus Washington held that what are called faithless electors, meaning members of the Electoral College who don't vote for who they're pledged to vote for, which in a close election could cause some really interesting and disturbing outcomes. The states can punish these individuals, but also I believe the states can replace them and have the alternate votes counted. And the Supreme Court has upheld the notion that states have control over the electors. And I think that that at least shows some degree of respect by the Supreme Court for the concept that these elections are state law elections and not federal elections, and that there really is no considerable place in most situations for federal courts to be involved in determining the administration and outcome of state elections. Can Congress react to a Supreme Court decision by passing a law that would reverse it? I would think there is a way of passing a law that would reverse a ruling without being unconstitutional. Yes, the answer is yes, if what the court was interpreting was a statute. So for example, in the gay rights case this time, had the outcome been different, and I think it's true there've been, and this is one of the points of the dissenters in the Bostock case, that Congress can amend the law and say, well, if you're not going to say that discrimination against gays is discrimination because of sex, we will just amend the law and say that discrimination because someone is gay is illegal. And that was kind of the argument of the dissenters, is Congress could do that, and since it hasn't, that allows us to interpret the meaning of the statute without that phrase in it, to which the answer is no. You don't look at evidence outside the document itself unless there's an ambiguity. And there isn't an ambiguity for the reasons Gorsuch said in the opinion. Because of sex means because of sex. And if you fire a gay man because he's attracted to a man, but a woman wouldn't be fired in the same position, that's discrimination because of sex. So yes, sometimes Supreme Court decisions can be reversed by passing a law. And so, for example, say the Supreme Court were to overrule Roe versus Wade. All they would be holding is that there's no constitutional barrier that prevents a state from making abortions illegal. At least in theory, although practically it would be a very difficult problem, but at least in theory, every single state could, or perhaps the federal government could find some basis under federal law, I doubt it, but every single state could make abortion legal. And there'd be no likelihood that the Supreme Court would say that that would be unconstitutional. I think I've covered everything, and I think I've covered most of the questions we have on the screen. If there are any other questions now, maybe either one of the board members can chime in with them, or someone can write it in a chat, but I think we've covered.
I think you covered, and I guess you just haven't given your own opinion about the future of the court.
Well, I will say this: it will depend a lot on the outcome of the election, and it will depend a lot on whether future opinions continue to degrade the independence and sort of neutrality that the court is supposed to have. And I'm not, I don't take public positions with respect to what the outcome of the election should be. But I also think there'll be a difficulty if, for example, we have a split between who controls the Senate and who controls the presidency. We'll have a great deal of difficulty getting anyone appointed to fill a vacancy. And we are going to have a vacancy soon. It seems very likely. I think the future of the court is very uncertain. I think the court has degraded its independence and its reputation through actions that at times are frankly very political. It's degraded things by and rendering itself less and less relevant by deciding fewer and fewer cases with meaningful precedent. And its opinions are frequently prolix, hard to read, and reflect a lot more about bickering amongst themselves than about providing decisions that would act as real, meaningful guidance and precedent to lower courts. So, if I were to give the Supreme Court a grade, it would get an even lower grade than I would give myself. And it would probably, at this stage, get a C minus at best. And that's not a reflection of my disagreement necessarily with its decisions, but just with the way in which it's handled its own reputation, the quality of its decisions, the enormous waste of resources and time in a very small number of cases that may not have that much practical impact, and ignoring vast areas of law where there could be better guidance given to the courts below.
Okay.
I'm sorry, Ann. Tom, you had a question
Yeah.
earlier. I don't remember if you ever got back to it, but it had to do with the legislative and oversight purposes and what the difference is, and specifically to the Mazars case.
Oh, yeah. Well, the two subpoena cases, Congress doesn't get to subpoena things just to do an investigation. Congress has to show, for example, if Congress is subpoenaing papers from the president, it has to show something like, this is relevant to a legislative purpose we have because we're considering a law regarding XYZ, and here's why the documents we're seeking are relevant to that law. And that's what they have to show. Whereas, and that I think is much harder to show because you have to show a broader purpose. It can't just be we're investigating, particularly when there's no longer an impeachment pending. It can't just be we want to find out what Donald Trump's doing. Whereas Vance, as a state prosecutor, could say he wants to subpoena things because he's investigating the Trump organization and or Donald Trump and or other officials in the Trump organization for potential criminal activity. And a great deal of deference is given to prosecutors in terms of information they're seeking to advance a criminal investigation. So the subpoenas are by no means equal. I mean, Congress, I think, may have a hard time coming up with a rationale that, in contrast, Vance could be seeking exactly the same documents as Congress or even more, and will have a much easier time meeting the standard because he's conducting a criminal investigation. So I don't think of the two cases, they get glommed together and everyone's just saying, well, the subpoenas are going to be enforced. I don't think that that's apparent. I think we'll find out whether the subpoenas are going to be enforced when they go back to the lower courts and they start going through the nitty-gritty. And I think the answer is Congress is going to have a very hard time and its subpoena probably won't be enforced. But I think Vance may well succeed in getting at least a significant portion of the documents he is seeking because the standard for him is different.